Another Community Legal Centres Queensland webinar. It's James from Community Legal Centres Queensland here. Can I begin the session by acknowledging the traditional owners of the lands on which we're electronically meeting. Rachael and I are on the land of the Yagara people, south of the Brisbane River. We acknowledge the Yagara and the Turrbal as the traditional custodians of the land that we now call Brisbane. But recognising that there are people tuning in from all across the country, pay our respects to elders, ancestors, and any Aboriginal and Torres Strait Islander people who might be joining us today from all parts of the country. A couple of housekeeping things before I hand over to Rachael to talk about family dispute resolution and the role of community legal centres in supporting clients through that process. We are hoping to have a recording of the webinar made available, and we'll, assuming that the technology works for us, we'll send a link around to that in the next day or two. We also circulated a copy of Rachael's PowerPoint to anyone who'd registered by about 5 o'clock yesterday afternoon, so some of you might not have received that. You should be able to download it though from the handouts area on your GoToWebinar control panel. There are a couple of ways that you can ask questions as the webinar goes through, but we probably recommend that you hold over questions until the end, and Rachael's left a bit of time at the end of her presentation for questions. Webinars don't really lend themselves to kind of a particularly interactive conversation, and so if you can hold your questions over till the end, that'd be ideal. But if you do have a pressing question, you can ask that question by pressing the button that looks like a hand on your control panel. We'll see something that looks like a hand going up at our end. You'll be able to unmute your microphone and you'll be able to ask a question. The other way that you can ask a question is to type something into the questions box. We'll read it and respond directly to that question. I think that's the housekeeping stuff kind of taken care of. So I might just hand over to our expert presenter to talk about supporting community legal centre clients in family dispute resolution. Rachael Field is a Professor of Law from the Bond University Law School. Importantly for us, she's also the President of Women's Legal Service in Queensland, has a really deep understanding of the type of legal help that community legal centres provide in this space. Rachael's teaching and research interests cross over a number of areas that are relevant to community legal centres, so family law, family violence, wellness and well-being in legal practice and other elements of legal practice that are really relevant to us. So it's great to have Rachael reflecting all of that experience and providing us with some insights into how we might support clients in family dispute resolution. Thanks and welcome, Rachael.
Thanks, James. And thanks everyone for making time today to come together and think about family dispute resolution and how in community legal centres we can best support our clients. So today, because it's the first webinar that I've done on this topic for CLC Queensland, I think what I've intended to do was just have a fairly general sort of introductory sort of discussion, and then we may do some follow-up work depending on whether there's a need or interest for that. So I'm really sort of going back to some fairly basic principles here in terms of talking about family dispute resolution, and essentially what we're focusing on today is talking about how the mediation process works in FDR, because that's essentially what FDR has become or is. So many of you would be aware that in 2006 there were significant amendments made to the Family Law Act, and part of that was trying to shift practice in family law parenting matters to have a far more heavy emphasis on the use of informal dispute resolution processes before the parties get to court. So at the time it was sort of talked about as mandatory mediation before attending court, but really it's not a mandatory process. It's just it is mandatory in terms of if parties want to file in the court later, they do need to be able to evidence that they've given mediation a go, or they need to be able to show the court that they were screened out of the process or have some other way of being exempted from it. So this now is really the prevailing culture, I guess, in family law around parenting matters in particular. And you know, the property matters they're supposed to be separate, and FRCs, family relationship centres, are meant to sort of really be focused on children's matters, but essentially things do inevitably get all mixed up. So there is the cultural context in which we're thinking about this stuff now is that there is this heavy emphasis on the use of FDR in family law. So you might expect that the amendments would have clearly defined what FDR was going to be if it was going to be such a strongly emphasised thing, but the definition of FDR is very vague. So it's just basically, it could be anything really. It could be counselling, it could be mediation, it could be, it's just a process in which an FDRP, and there's some regulations around how you become an FDRP. You need to satisfy certain conditions to be registered. So an FDRP helps people affected or likely to be affected by separation or divorce, and helps them to resolve some or all of their disputes with each other. The practitioner needs to be independent of all the parties involved in the process, but basically it's anything that's not going to court, anything other than a judicial process. But over time, and I mean even at the start when this was first introduced, family mediation was the thing that was predominantly used. So we can look now to the National Mediator Accreditation System for a definition of mediation. And generally FDRPs will be accredited as well under the National Mediator Accreditation System. That system is a voluntary system, was introduced in 2010, and it's administered by the Mediator Standards Board. Their most recent definition of mediation is the one that's on your screen now, and the emphasis of the mediation process is on promoting self-determination for the parties. So each party, it's relational self-determination. It's not self-determination just for one party, it's for both. And essentially that means that they are in control of the dispute and the outcome of the dispute. So the mediator's role is a supporting one. They're there to assist the parties to communicate with each other, to clarify and identify and explore interests and issues and needs, consider alternatives, generate options and evaluate those options, generally negotiate with each other. Mediation is just really a framework for a negotiation process, and reach and make their own decisions. So the important distinguishing thing about mediation is that the mediator doesn't have any decision-making role in the process. It is really up to the parties, and that's a benefit of the process, is that they have this self-determination that's possible. So the positive aspects of FDR in family law matters, and there are lots of positives about using this process and getting, particularly parents who are going to have some sort of ongoing relationship around the care of the children, talking to each other and able to make agreements with each other, because down the track hopefully mediation will have enabled them to have an approach, and it would have modelled an approach to communication that they can then use themselves if things need to change, if arrangements need to be made different. Excuse me, just coughing. So in terms of some other positive aspects, the collaborative and cooperative discussions are important. The fact that parties can articulate their emotions. We can distinguish mediation in this regard, I suppose, from what might be seen as legally relevant. When we're in court and the parties are able to sort of explore with each other what their needs and interests are. And the point there to make is that when we're representing people in the more formal litigation kind of setting, it is more about the parties' positions. So it's what the parties want, what they want as an outcome. But mediation is much more concerned, or yes, it's concerned with getting beyond positions. It's concerned with getting to why parties want what they want. And that's a really great thing about mediation, is that when you say to somebody, why do you want that? You start to open up, you understand where they're coming from or what's motivating their position, and you start to open up some the possibility of being able to satisfy why a party wants something with other options other than what they say they want. So it starts to create opportunities for mutual agreement. And that's a wonderful thing about mediation. It can also save the parties time and resources, so it can be a positive thing in that regard. But I think one of the best things about it is that, and the hope is that through experiencing the FDR process, the parties will have a better sense of effective and constructive communication and a sense of putting the best interests of the children first in terms of arrangements that they're making. But having said that, and a lot of the articles that I've written are fairly critical of FDR actually. I teach FDR. I've recently redone my training as an NMAS accredited mediator, and I'm doing my accreditation to be an FDRP at the moment. But the process has to be used wisely, and it has to be. We have to really diagnose people into FDR, I think, and make sure that it is the appropriate process for them. And I suppose that, obviously the greatest concern is that self-determination is only possible for parties where they are on a relatively equal footing. And so where there's a power imbalance between the parties, where one party is particularly vulnerable compared to the other, then that opportunity for self-determination is really, it becomes impossible really. So that's why there are provisions for matters where there's a history of domestic violence to be screened out, and often in the intake process for FDR, where clients identify that there's a history of violence, they may be screened out. But there are just so many matters involving a history of domestic violence that are coming to FRCs, family relationship centres, that just the mention of a history of family violence won't necessarily mean that the matter won't go through FDR. So I think, having said that, I think the role that we have in community legal centres in terms of providing support and advice to parties going in to FDR is really important. And it's interesting to see that the government is, looking to have more legally assisted FDR happening in response to the family violence initiatives, that third action plan. I think legally assisted mediation is a part of the answer, but I think also there's a lot of scope for us in CLCs to be helping the parties to prepare to go in, particularly where they're not going to be represented. But we need to sort of shift our thinking a little, and I think in CLCs we've got a very rights-based sense. We're fighting for people's rights, we're fighting for the vulnerable, we're advocating for justice for people who otherwise are not being treated fairly by the system. And mediation asks us to make a slight shift from that rights-based, like what is the client entitled to something more like what can the client live with, what's safe for the client, what can help the client move forward. Not necessarily the absolute best outcome in terms of what the law might say, but what is best for this family in terms of moving forward. Some other difficulties are as well that the skills and experience levels of the mediator are not consistent around Australia. So the national accreditation system is really great, and that's helping to bring standards and the quality of mediation practice up. If I was advising anyone, well, FDRPs have to be registered, so there is a quality measure there as well. But it's always good to just sort of be aware, if we're helping clients, if it's possible to know who the mediator is and what their skills are, that's useful. And there are also different models of mediation, and because the definition of FDR is so broad, all of those models fit within what might be seen to be FDR. The most common model, and it's the one that I'm just going to use today to talk through the process, mediation process, is the facilitative model, and that's the model that the National Mediator Accreditation System is based on. So I'll use that one to talk about things today, but there are other models. For example, the transformative model of mediation, which is less about problem solving and more about assisting the parties to transform their dispute resolution practices. And there are other models like narrative models, and there's also an evaluative model where the mediator plays a far more evaluative role, still not making a determination for the parties, but assisting with evaluating, options and outcomes and so on. That model isn't really one that is practiced much in family dispute resolution. It's more a commercial model. And then the ethics of practice is another issue. We don't really have time to talk about that today, but the theory around mediation is that the mediator should be neutral, and of course mediators can't be neutral. And in family law matters, it's the concern is that the mediator might influence the outcome of the parties in ways that they're managing the process, and through managing the process they're able to manipulate the parties into particular outcomes that fit with their value system, not necessarily the self-determination of the parties. But given that the mediation process is generally confidential, it happens behind closed doors, we don't really know what's going on in practice, and unless parties complain about that a mediator was biased or behaved inappropriately, there's not much we can really do about that at this point. So some of you may have heard of the Coordinated Family Dispute Resolution process. That was a process that at Women's Legal Service here in Brisbane, we were commissioned by the Federal Attorney General in 2009 to design a model of mediation specifically for matters where there was a history of family violence. And so we designed this model with a particular focus on risk assessment, having a case-managed approach, a really strong emphasis on party preparation going in. We used a facilitative model of mediation to keep things simple, and it was a lawyer-assisted model of mediation as well, with the lawyers in the pilots of this process that happened around Australia, and there were 5 pilot sites, and all of those pilot sites used community legal centres, apart from the one in WA, which was in legal aid, used CLCs as the lawyers for the lawyer-assisted model. So if I just move to the next slide, this is a graphic of the model, and you can sort of see why it wasn't resourced post the pilot, because it is extremely resource intensive and it's quite complex. So so this is, when I'm thinking about the fact that this third action plan is looking to sort of develop processes that are effective for matters where there's a history of violence, we do actually already have a federally tested model that was evaluated, this model, that the Australian Institute of Family Studies evaluated this as being, and said that it was cutting edge, and that it was much better than sending parties into the standard mediation process, and much safer where there was a history of violence. But it is resource intensive, and it requires a commitment from government to to commit to those resources going in. So we don't have this model as standard in FDR, but I think it gives us a good sense of what we should have in FDR, particularly for matters where there's a history of violence and where there are vulnerable clients. So we're advocating for that at Women's, quietly. But today, because we don't have that model, the work that we can do in CLCs in helping the clients to be prepared going into the standard FDR process is so much more important, given that often our clients are vulnerable. So these are the things that we can, or I want to focus on just for today anyway, that we can assist clients with. We can help them understand the philosophy of the process, so going in, understanding the nature of the negotiation environment that they're entering. We can help them with each of the steps in the process, because that will mean that they are more able to negotiate effectively through the process and behave in a way that's going to be in their interests in each of those steps. And through talking about those things, we'll come to an understanding, which is also really important for the parties to have, which is of their own responsibilities in the process, as well as what the responsibilities and role of the mediator is. And then we'll finish up with just some other general sort of negotiation and communication skills coaching things that we can do with clients. So we've talked about some of the mediation philosophy, particularly the focus on self-determination, and that is really the critical thing for clients to know, that the third party, the mediator, who's going to be facilitating the process for them, is absolutely not there to make a decision for the parties. So they have to go in prepared to talk through things with each other and to be guided by the mediator, but they must be engaged with coming to a decision about what arrangements to put in place about the children. They need to understand that it's an interest-based as opposed to a positions-based process. So they need to think through why do they want things, what are their motivations, and we can help them put the children's best interests front and centre of that interest-based situation. The parties need to know that the focus of mediation, the theory around mediation, is that it is possible to negotiate mutually satisfactory outcomes. Even where parties are at odds with each other, the mediator will be seeking to facilitate the process so that they come around to a mutually satisfactory outcome. They need to know that the process is flexible, so we can prepare them for each of the stages of the process, that mediators have a lot of flexibility in terms of how they manipulate the process. The more experienced a mediator is, the more they don't stick to the generic steps. There's a lot more artistry in what they do. And we also need to assist the parties with generating options, because often they're not at the best time in their life of coming up with creative solutions, which is what the mediation process is asking them to do. So if we can help them before they go into a mediation process with generating a range of options on a spectrum of things that they can live with, then that's going to be great. And in that sense, we have to think beyond just what the legal remedies are in a situation. Okay, so to talk about the 7 generic stages of mediation, these are taken from the facilitative model of mediation. So we'll take each one of the numbered stages there. The preparatory matters are really important. That's intake into the FDR process, and that's very important in terms of that is an opportunity for the clients to discuss if they do have concerns about going into a process that is effectively asking them to be relatively equal in their capacity to negotiate in their own interests. So if a party has any concerns about being able to do that, if there's a history of violence or some other vulnerability, then it's important that they raise that with the person doing the intake for the FDR process, so that it's, if they do that and then there is an assessment made that it isn't appropriate to go ahead, then they can still get a certificate to say that they that was the decision that was made, that the FDRP screened them out of the process. So it's important that clients know that that opportunity is there. But if our clients are actually going to go into a mediation, and at Women's, one of the reasons we took up the opportunity when the Federal Attorney General asked us to design that model of mediation was because we could see that our clients needed something. So if we weren't involved in working towards coming up with a safe model of mediation for matters where there's a history of DV, then we were essentially saying that our clients either had to negotiate around the kitchen table or with the perpetrator, or represent themselves in court. And we felt that there was an onus on us to at least contribute to discussions about what might be a safe form of mediation, because as well our clients were saying they would prefer to actually have a supported way of talking about how to finalise arrangements about the children. So, so that's a bit of why at Women's we were involved in it, in that CFDR design process. So let's just talk through the stages now of mediation. So the first stage is where the mediator makes their opening statement, and that's providing the parties with an explanation of the process, the mediator's role, and the role of the parties. So this should be something, and we can assist our clients by making sure that they understand all this information before they go in. We should really be doing a mediator's opening statement with the client, in terms of how we are explaining to them what they're going to be participating in. So we should be able to advise clients about the features of mediation, that the mediator is going to say that they're impartial, but that they are just there to facilitate the process and they don't get involved in the dispute per se, if that's up to the parties. We have to let the parties know that the legislation expects them to make a genuine effort in the process. Realistically, the FDRPs are not assessing genuine effort. It's basically if you show up, you've made a genuine effort. They see that as a breach of their impartiality to have to make that judgment call. They don't like it. Confidentiality is something that needs to be mentioned, and the best interests of the children also. I haven't got that on the list, but it is important to that the clients know that the mediator's emphasis is the best interest of the children, and that's required by the legislation. And we need to let the clients know as well that some ground rules will be set. So usually the ground rules for mediation that the mediator sets right up the front is they are that only one person will speak at a time, so no interruptions. That's quite difficult for clients in family law disputes, and people who once loved each other and now hate each other do find it difficult not to interrupt each other. But that will be set as a ground rule, and the mediator will use that to control the dynamic between the parties throughout the process. So they'll come and say, Rachel, remember that you committed to the ground rule not to interrupt at the start. I need to ask you to not interrupt. You've got a piece of paper in front of you. You can write things down. So because the parties are often quite anxious at the start of a mediation, it's really important that they actually don't hear a lot of this stuff that the mediator says. It's a bit of a buffer between coming into the room and then getting started. It sort of allows them to sort of calm down a bit, but they actually don't hear a lot of this. So it is really important that if we're advising clients who are going to mediation that we let them know all of this stuff. So then once the mediator's opening statement has been made, then generally the parties will be asked to make their statements. So this is the narrative part of the process where each party is given a voice, and they're given a voice to articulate their own perspective on matters and their needs and interests and concerns. And that is the start of the negotiation process. Some clients sort of say that, feedback on having come out of a mediation, that this is the first time that they've, in a long time, that with the other party, they've actually had a chance to say how they feel uninterrupted, and they've had a chance to acknowledge emotions and to get their perspective across. And the role of the mediator in supporting that uninterrupted voice is really important. So each party makes their statements, and the mediator will summarise those statements and so read them back to the parties, which is a way of, so when a mediator summarises those statements, they take out any accusatory kind of language, they start to neutralise the problem, they reframe things in terms of the best interests of the children. So that's a really important thing in it, and in terms of the parties, they say their perspective, but then they also hear the mediator neutralising the issues, and that helps to sort of move to the next stage, which is the setting of an agenda. So what we can do is assist clients to prepare their opening statement ahead of time. They need to be able to identify their key needs and interests and concerns and be able to articulate them. So, even helping parties to practice ahead of time, going in with a set of doc points about what they want to say. That means that they're ready to go, and that they won't be sort of deer in the headlights when the mediator says, so Rachel, now's your opportunity to sort of tell us what your needs and concerns are here today. So that's an important stage of the process, and it does lead to the next stage, which is setting an agenda. The agenda is sometimes referred to as the backbone of mediation because it provides the framework for the negotiated discussions, and it provides a roadmap. So the mediator will assist in the formulation of the agenda using the summaries of the party statements that they made. Generally in FDR, the agendas are fairly consistent. They tend to be who will the children live with, who will the children spend time with, communication between the parents and things like that. But they could be more specific, what school will the children attend, or go to those sorts of issues as well. Mediators always use neutral language when they're setting an agenda, so they don't use language that will be blaming anyone. They often, in FDR in particular, they'll often set the agenda by using questions. So each item on the agenda is a question, and that the intention behind that is to motivate the parties to try and answer the question. The parties are given, so the mediator will write the agenda essentially, but the parties are then given an opportunity to prioritise the items on the agenda. And so it's important that we enable our clients to go into the process with a sense of what's most important for them to discuss on the day, and what they would say is the first issue that they would like to discuss. And so there's a bit of a typo on this slide, sorry, it says feel able to negotiate the agenda times. It should say items, sorry, that's my bad. So once the agenda is set, then that is basically used then for the clarifying and exploring stage of the process, which is where each one of the issues is taken separately, and the parties are supported by the mediator to talk to each other. That can be confronting to them, that they will be, it is, Rachel, tell James how it makes you feel when, and James, if there's something, tell Rachel what you think you might be able to do differently. So often the parties will tend to sort of, start to talk to the mediator, and they'll always be brought back to talking to each other. So preparing the parties for that is really important. But also, and at this stage of the mediation, it's very helpful for the clients to have a good sense of what the law is that sits behind the negotiation. So to have this stage of the process informed by the shadow of the law is another thing that we can assist with in CLCs. So at some stage during the exploration process, the mediator will probably decide to have some separate sessions with each of the parties. The aim is so that the mediator can check in with each of the parties and talk about how they're feeling in the process, and how they're feeling that how the negotiations are going. Mediators also use this to assist the parties to develop some options. They ask a curious questioning to sort of see if more options might be generated. And they also, if a party is being sort of is resisting exploring options, or is very set in their position, they'll use reality checking techniques to sort of to try and shake them out of that fixed position. So they will challenge entrenched positions and try and encourage the parties to take a more compromising approach if they're in those entrenched positions. And the mediator will also help the parties in the separate sessions to rehearse negotiations for when they go back in together. It can actually be quite confronting for the parties to see the mediator walk off into a room with the other party alone. They don't know what they're saying in there, and it can be challenging. So it's important for the clients to be ready to use this stage for themselves, so ready to talk to the mediator if they are experiencing difficulties, but also to understand that it is just a part of the process, and that it is a confidential part of the process. So the mediator would never bring back anything from a separate session to a joint session without the parties' consent. And then after the separate sessions, the final sort of identification of options for agreement are developed, and those options are then explored in more detail and discussed, hopefully with a view to reaching a mutually satisfactory final outcome. That's a bit of a cynical thing in brackets there. There is amongst mediators sometimes a bit of a sense that to not reach an agreement is a failure, and so we need to be careful on that, because sometimes for our clients just reaching a partial agreement on some of the matters is a good step forward. It doesn't have to be a full agreement. So yeah, but again, that's an issue for mediators that they need to deal with. And I suppose in terms of what we can do, again, it's the shadow of the law, I think, that's really important in terms of the outcomes. In order for a client to be able to decide whether they can live with something, they really do need to be able to measure that against what might happen if they did take it to court. So that's really important. Okay, so I think, and then there's the final agreement stage. So the mediator will generally be the person who will write up that agreement, and then they congratulate the parties. But our clients should be feeling that they don't have to sign anything on the day. They might want to have a bit of a cooling off period. So they need to feel that they have the power to sort of say, no, I need some space to sort of think about this, because they may feel under pressure to sign something on the day. So that's the process. And now, just to, while we're in the time that we have remaining, just to talk through a few of the other things that we can do and how we can assist our clients. So one of the first things is, if there is a history of violence, that we really need to encourage our clients to identify that before the mediation takes place. And if they haven't, then the private session is a good place as well for that to be raised with the mediator. One of the models of mediation you may have heard of as well, that's sometimes used where there are vulnerable parties, is the model of shuttle mediation. That's where the parties are in different rooms and the mediator will go between them. So in some matters where there's a history of DV, shuttle mediation will be used, and that can be a good option. I tend to sort of think that if the parties can't be in the same room together, that's a red flag to perhaps mediation isn't really appropriate in that situation. But nevertheless, a lot of people do end up in mediation where there is a history of DV, and it is quite difficult for them, and it may be unsafe. So what we can do in terms of ensuring safety is also really important. If we can assist the client with a safety plan before and after the mediation, and if it is possible to help them know what the coming and going arrangements are at where they're going to the mediation, and whether they're going to have to go in the same door and out the same door, and what the car parking arrangements are and everything, that's really important. There was a matter at the end of last year where a woman was killed by the perpetrator in Western Australia at a mediation. So, this safety issue is really critical. It's possibly a good idea even to suggest that the client goes and has a look at where the mediation is going to take place before the day of the mediation. And as with advising clients when they're going for family report sessions, it's always really critical to advise them leave plenty of time to get there. Make sure that nothing else on that day is going to distract you from being focused on the process. Yeah. So on the next slide then, advising clients to take notes to the session is also sometimes helpful. If you've given them legal advice and you can give them a summary of that legal advice, that can be helpful. As I said before, assisting the client to prepare their opening statement ahead of time and have some dot points about what their needs and concerns are going in is very helpful, and particularly if we can also then help them to practice reading it out loud, then they're going to have confidence to sort of participate in that part of the process more effectively. It is important as well to encourage the client to think about what the other party is going to be saying, what they want, and where their needs and interests are falling, so that anticipating that to some extent will sort of assist with cutting off some of the shock of what might be said in the process. Because sometimes clients, parties in mediation will try and push each other's buttons, and so anticipating some of that is helpful. Helping the client develop a range of options is really important. As I said before, clients, when they're going into mediation, are often not in the best place to do what the process is asking of them, which is to be creative thinkers about their legal problem. So where we can step in and be creative thinkers about that, then that's a really great role for us. And encouraging the client to think that mediation is a process where some compromise is going to inevitably be necessary. So helping them identify, well, what are you prepared to move on? What is your bottom line? What are you prepared to think about compromising on, and what are you not prepared to think about compromising on? And also, in dispute resolution land, we call it the best alternative to a negotiated agreement. What's going to happen if you don't get an outcome through the mediation process? What are your options then? Doing a bit of reality checking about that. Does that mean that you're going to have to end up representing yourself in court? Is it, so what will you do if mediation fails? In terms of the communication coaching that we can do, active listening is a really important thing to assist clients with. Helping them with some strategies around attentive body language, using clarifying questions, verbal following skills, empathetic questions and summarising. All of those things can really lift the dynamic in a mediation, and the mediator will be modelling all of these positive communication strategies. But if our clients can also be going into the process intending, and it's not easy and they don't get it perfect all the time, but if they've been coached to use some of these active listening skills, then that will certainly assist the dynamic and support the process reaching an effective outcome. Another thing, the T in there is timeout, which is indicating, asking for timeout is actually quite fine. Parties can do that if they're feeling tired or overwhelmed, or they just feel like they need to take a break. It is actually a positive thing to do, because it's appreciating the value of the communication to say, I just need to take a break before we come back and keep going. So also encouraging the parties to use eye contact, particularly with the mediator, maybe not with each other. It can be difficult, but the mediator will be asking them to talk to each other, and so expecting some eye contact is important going in. And just helping them with things like, breathing going in, and regulating, how they're speaking, and just trying to settle the clients. The ground rule is going to be one that the mediator will keep coming back to, that only one person speaking at a time and no interruptions. And so if we can assist our clients with expecting to be given a piece of paper and to be writing things down rather than interrupting the other party, then that's going to assist the dynamic as well. And if we can, behaviour like rolling your eyes and banging the table and pointing fingers and stuff will be called by the mediators. They'll say that's not appropriate behaviour for a mediation. So if clients can be prepared to try and not do that, then that's good as well. So finally, final things to encourage the client to do. As I said a bit earlier, let the mediator know if they're having any trouble or if they're experiencing difficulties, ask for time out. Encourage the client to reality check what they want and also what the other party says they want. How realistic are the options that they are saying they want to see come out of the mediation? Encouraging the client to use the language of the best interests of children will help the dynamic of the process. And just going in expecting all of these things, expecting things not to be necessarily completely smooth sailing, and the other party might be pushing buttons and trying to upset and control the process, and giving the party some strategies and techniques to manage that, which is usually just to use a piece of paper and pen in front of them to write things down if they're upsetting them. So I think that's the end of what I wanted to say today, and I think the conclusion really is that there's a lot of potential for us in CLCs to assist people going into FDR and into any mediation process actually. All of what we've said today is in the context of FDR, but it applies equally to any mediation. So these techniques and these strategies and this knowledge, I think, if we can better assist our clients to be prepared for the process, then they will participate more effectively and the outcomes can only be of a better quality. Yeah.
Terrific. Thanks, Rachel. Yeah. Thanks, everyone, for listening to Rachel's presentation. Incredibly useful and really practical, which is always a really important thing when in these webinars. Reminder about a couple of ways that you can ask questions or contribute to the discussion. One is to type a question into the questions box on your GoToWebinar control panel. And the other is to press that button that looks like a hand, and we'll see something that looks like a hand going up at our end, and we'll be able to unmute your microphone. While some of those questions are starting to come through, I should have mentioned earlier, this is the first of these webinars that we're delivering in partnership with the Community Legal Association of WA. So if you're a WA practitioner, you're entitled to a CPD point under a more regulated system than we have here in Queensland. So So you can contact the association in WA to have a certificate or record made available. Chrissy's come through with a question, Rachel. She's asked, do you recommend that if agreement is reached that the agreement be formalised into consent orders and not a parenting plan?
Yes, I think I would. I would recommend that. Yes.
Oh, easy.
Yeah.
The answer is yes.
Yes.
Patrice, it looks like you've got your hand up there. Did you have a question?
Actually, on that other point though, I guess there are pros and cons, aren't there? I mean, if I would check in. I mean, obviously you are checking in with the client, but the client has to feel really. I mean, obviously consent orders, they have to be really firm about those arrangements being right for the client. But also, once those orders are in place, I still think clients should be encouraged to think that they can go back to mediation, especially if the children are young. And the needs and interests of the kids are sort of going to change over shorter periods of time. That in those sort of circumstances, then and particularly where the clients are vulnerable, I would suggest that having consent orders in place is important, but that still some sort of sense in the client of the flexibility moving forward is a good idea as well.
And not only in the client, but that both parties understand that that's where the space that they want to be in.
Yes, that's right. Yeah.
Patrice, I might try you again. Did you have your hand up on purpose? Have you got a question there?
No, I don't.
No. All right. Thanks, Patrice. I'll.
So on the front page of these slides, I've included my email address at Bond. So I'm also very happy if anyone's interested in any further information, or if, for example, the CFDR stuff or whatever, if you just email me, I'm very happy to give you that information.
Terrific. We might actually circulate that, because I think that would be really useful. Rachel flagged the role of some form of enhanced FDR under the 3rd National Action Plan for the Prevention of Violence Against Women and their Children. Just to provide a little bit more meat around that for those of you managing community legal centres. Over the next 3 years, there'll be $6.2 million made available to FRCs to apply for funding for enhanced FDR where violence is a feature of the relationship. Those applications from the FRCs will need to be made identifying a legal services partner. And so for those of you that have existing relationships with FRCs, and there are many of you because it was a funded specialist sub-program from about 2009, a number of you, and while that funding is right up, a number of you have continued your relationship with the FRCs, the Family Relationship Centres, recognising the value of being able to do exactly the kind of work that Rachel's been talking about today. And so it might be worth starting to have a conversation with them about what a more thoughtful, deliberative process might look like that recognises the vulnerability and the needs of victims and survivors of violence. So I might distribute some information about that model because that will be useful for many of you, I'm sure.
So Angela Lynch, who's the acting CEO of the Women's Legal Service, and I wrote an article which I'd be very happy to just circulate.
Terrific.
Yeah. And then there's also the ACE evaluation. We can circulate that.
Brilliant. So we are shortly about to run out of time, but we could probably take 1 or 2 more questions if you've got them. You can raise your hand or type a question into the questions box. Rachel, one thing that I wanted to ask about, we talked about the screening process, recognising vulnerability, and given that so much of the work of community legal centres is in the space of family and domestic violence, what are the other indicators of vulnerability that might be used to screen our clients out of a process like this at the moment? Family violence is probably the overriding one, but are there others that you see in practice?
Well, basically what mediators, when they are doing their intake and screening process, what FDRPs are looking for is the issue of capacity to engage in the process. So vulnerabilities around anything that could impact on a person's capacity to negotiate on their own behalf is an indicator of potentially the process not being appropriate. So yes, it's because the focus is so strongly on self-determination of the parties that they have to be able to, even if they're supported, even if they need some support going in, they still have to have an elemental ability to represent their own interests in the process. Otherwise, they really need a third party to make the decision for them.
Which brings me to one of the questions that's come through in a way, and it's not something that you concentrated on particularly because we didn't ask you to, but the role of a lawyer in a lawyer-assisted family dispute resolution process.
Yeah.
Where do you think lawyers can and should be adding value
if
they are in the room or on the end of a phone or something with a party to an FDR?
Yeah, well, I think we've got a role before, during and after. I think lawyers are really, I mean, I'm really pleased to see that the emphasis is moving, particularly for vulnerable clients, to having legally assisted models. But what we have to do then is change how we are thinking as lawyers going into the process. If we go into it with our adversarial mindset, we're going to disrupt the process. It's not going to work out, and lawyers actually have quite a bad name with FDRPs in terms of doing that, upsetting the process, being positions focused instead of interest based, and so we have to sort of change our thinking around that. That's part of what I do in
Another question that's come through, Rachel, if there's a family violence history, how do you apply for a Section 60I certificate?
The FDRP can issue the certificate that says that screens you out. So you get one via an FDRP, who when you talk with them, you will explain that the client is there's a history of domestic violence, and that it's not appropriate to proceed, and then the FDRP will make their assessment of that by talking to the client, and then if they agree, then they'll issue the certificate. Yeah. And
it's only FDRP that can issue those certificates? If someone's seeing a counsellor or?
No, it has to be an FDRP. Yeah.
Just a couple more questions quickly. Do you recommend to clients, not just put it as an option, but recommend it, that they should not feel compelled to sign any agreement, but to say that it would be subject to obtaining legal advice?
Yeah, definitely. Particularly if the client hasn't had a full legal advice, or if they're just feeling unsure, and if there isn't a lawyer there, then it is the cooling off period is important, because we know that clients can get very tired through the process. FDRs can often take sort of 3 to 4 hours, and there is some empirical work that has established that parties will just agree to anything sometimes at the end just to get out of there, and just because they're exhausted and they don't want to talk to that other person anymore. So I think having the client feel that they can make that call, it's great if they can go in with enough legal information and enough preparation to know whether the options that they are agreeing to are good for them. That's great, and then they can sign off on them if that's the case. But where they're unsure, then I think it is safer to go back to get legal advice on it. Yeah.
And the last question that we might take for today, and it's kind of a biggie, in country areas, so where there isn't an FRC or some other type of FDRP operating locally, what are the alternative options that might be available for clients who are coming into CLCs?
Well, I would particularly recommend the telephone dispute resolution service, the TDRS, which is run out of Relationships Australia here in Brisbane. So that is definitely an option. They do mediations around the clock with people in diverse parts of the country, and do it all by phone. And they have also other technology and stuff that they use. So I'd recommend the TDRS, but I also think it is a good idea. I mean, that idea of training our own, I think, for people in rural and remote areas, getting the FDRP training as lawyers is a positive thing to do. Yeah.
Terrific. A couple of quick points on that. One is thanks for the plug for Relationships Australia, where I'm on the board, so I should probably put that out there. And the other is I think there's an increasing number of CLCs that are having an interest in developing some type of mediation service, and as Rachel's kind of a theme that's, or a thread that's come through a lot of the conversation today, is it actually takes quite a dramatic mind shift sometimes from advocating for the rights of one party to settling this kind of stuff. But I think there's some really interesting models happening around the country where CLCs are starting to develop their own mediation practice and they're delivering great outcomes for their communities, and that's a really exciting development.
Yeah, that's great.
A phone number for the TDRS. I don't know that either of us have that off the top of our head, but thanks, Barbara. We will distribute that with a follow-up email.
Yeah, that's what we can do. Yeah.
Terrific. Rachel, on behalf of the people clapping and cheering wildly at computers across the country, can I thank you for what, as I said before, was a really practical and thoughtful presentation on how we can be supporting our clients through family dispute resolution.
Thank you. Thanks for inviting me. It's too much fun. It's too much fun being here. Yeah, thank you. Yeah.
Folks, thank you all for listening. We'll distribute some follow-up information shortly as well. Reminder for WA people, you can do the thing that you need to do to claim your CPD points now, which is great. And we'll look forward to speaking to you soon. Thanks, everyone. Have a great day.
Thank you. Bye.